Family Court, You Be the Judge, Episode 7, The Child Who Wanted to Live with Dad. What happens when a 13-year-old says, I don't want to live with Mum anymore, I want to live with Dad? Can she simply choose? Can a court stop her? And what happens when both parents are good parents but completely disagree about what's best? Today, you're the judge. Hello and welcome back to Family Court, You Be the Judge. I'm Neil Andrews. I'm a qualified and regulated paralegal and a Mackenzie friend, which means I help people who are representing themselves in family courts to understand the process and prepare their cases. As always, this is a fictionalised composite scenario based on the kinds of issues that regularly come before the family courts in England and Wales. No real people, no real cases, no identifying details. Every case turns on its own facts. And if you're enjoying the series, please do like, comment and subscribe. It genuinely helps the channel grow and helps more people find information about the family courts. Now, last time I left you with this. A 13-year-old girl says she wants to move permanently to live with her father. Dad supports the move. Mum opposes it. And I asked you, should the court allow the move? Should it keep the arrangements exactly as they are? Should it order 50-50 care? Or should it investigate further? If you haven't already, pause the video and put your judgment in the comments. Right, let's see what happened. The background. Mum and Dad separated several years ago. There is already a child arrangements order in place. The order says the child lives with Mum. She spends alternate weekends with Dad. One overnight during the week with Dad also. The school holidays are shared equally. The arrangements have broadly worked. Not perfectly, because very few family arrangements ever do. But well enough. Until now. The child is 13 years old, and one day she tells both of her parents, I want to live with Dad. Not for a few weeks, not for a trial period, permanently. She says she feels happier there. She says she gets on better with her father. She says she feels more understood. There is less arguing. She feels more relaxed. And she says, I don't want things to stay the way they are. Now, if you've parented a teenager, you'll know those words can hit pretty hard, because suddenly you're asking yourself a very difficult question. Is this simply a phase, a reaction to an argument, or is this something much deeper? Mum is devastated. She says this has come out of nowhere. She says her daughter is reacting to normal teenage boundaries. At Mum's house, there are rules, expectations, consequences. But at Dad's house, she says, things are more relaxed. Dad is the fun parent. And she says her daughter is choosing the easier option. Mum also says something I hear all the time. She's only 13. She doesn't know what's best for her. Mum wants the arrangements to stay exactly as they are. Dad sees things differently. He says these feelings have been building for some time. He says his daughter is mature and thoughtful. He says she shouldn't be forced to live somewhere she says she's unhappy. And he says the court should listen to what she wants. So Dad makes an application to vary the child arrangements order so that the child lives with him. The issues. Now, you're the judge. What do you do? Option A, allow the child to move to live with Dad. Simple. Option B, keep the existing arrangements exactly as they are, so she continues to live with Mum. Option C, adjourn and investigate further. Option D, order 50-50 shared care. I suspect quite a few of you picked option D because on paper it sounds fair. Nobody wins, nobody loses. Everyone gets equal time. Problem solved. But is it? Because if a 13-year-old is saying consistently and strongly that she no longer wants the arrangements that are in place, would 50-50 actually solve the problem? Or would it simply create another one? Keep that in mind. Let's bust one of the biggest myths in family law. There is no age at which a child gets to decide where they live. Not 12, 13, not even 16. There is no magic birthday. The court's job is always exactly the same, to decide what arrangement is in that child's best interests. Now, one of the things the court has to consider is the child's wishes and feelings, of course. But the Children Act says something really important. It says that those wishes and feelings are considered in the light of the child's age and understanding. And those last few words matter because the question isn't simply, what does this child want? The question is, how much weight should I give to what this child wants? And that's completely different. A 17-year-old's views might carry enormous weight. A 13-year-old's views may carry significant weight. A younger child's wishes may carry less weight. But every child is different. Every case is different. And even then, the child's wishes are only one part of the picture. The court is also considering emotional needs, the likely effect of any change, each parent's ability to meet the child's needs, any risk of harm, and all of the other welfare factors. We looked at them in the last episode, but I'm going to put them on the screen here again if I haven't already. A challenge is something I often see. I see this all of the time on my Facebook group link. Somebody will post, "The judge listened to my child and made the order my child wanted." And look, I completely understand why it feels that way, but that's usually not what has actually happened behind the scenes. The law doesn't say whatever the child wants, the child gets. What has usually happened is this: the court has considered everything, all of the evidence, all of the welfare factors, and after doing that, the child's wishes happened to align with the outcome the judge considered to be in that child's best interests. That's not the same as saying as the child made that decision. Sometimes the court agrees with the child, sometimes it doesn't. And with younger children particularly, it's very common for the court to make an order that is different to what the child has said that they want. The fact that the court agreed with the child can sometimes be coincidental. It's not determinative. The child's wishes are important, sometimes very important, but they are never the only factor. The court's question is never, what does the child want? It is always, what is in this child's best interests? And sometimes those two answers happen to be exactly the same. As the case progresses, more information comes before the court. There are no safeguarding concerns, no allegations of abuse. Both parents are loving and capable. Both homes are suitable. School attendance is good, school performance is good, and perhaps most importantly, the child has been expressing those wishes consistently for several months. She can explain why she feels the way that she does. This doesn't appear to be impulsive. Professionals spend time speaking with her, and they conclude that her views appear genuine and carefully considered. Another issue comes to light. The relationship between mother and daughter has become increasingly strained. Arguments are becoming more frequent. Communication is deteriorating. The daughter feels unheard. The mother feels disrespected. And both are becoming increasingly entrenched in their positions. The child genuinely believes she would be happier living with dad. The decision. So, what happened? The court varied the child arrangements order. The child moved to live with her father. Now, I can already hear some people saying, so she did get to choose. Not exactly. The child didn't choose. The court decided, but the court placed significant weight on her wishes and feelings. Why? Because she was 13. Her views had been expressed consistently. She appeared mature. Her reasons were thoughtful. There were no concerns about Dad's ability to care for her, and the judge concluded that in all of the circumstances, living with Dad was in her best interests. Why not 50-50? Could the court have ordered shared care? Yes, absolutely. The court could have, but it didn't, because the judge concluded that a 50-50 arrangement wouldn't actually address the issue. The child wasn't asking for a bit more time with Dad. She was asking to change where she lived. And in this particular case, the court decided that imposing a compromise wasn't the right answer. Different facts could have easily produced a different outcome. The takeaway. If your child says they want to change homes, don't panic. Don't tell them they're betraying you. Don't put them in the middle. Don't promise them they'll automatically get their way. And don't simply ignore what they're saying either. Listen. Ask questions. Try to understand why. Because sometimes it's a phase, sometimes it's frustration, and sometimes it's something much deeper. So, was this your judgment? Would you have allowed the move? Would you have kept the arrangements as they were? Would you have gone for 50-50 care? Let me know in the comments, because I think this one is really going to divide opinion. And if you've enjoyed today's episode, don't forget to like, comment and subscribe. Okay, next time. An 11-year-old boy hasn't seen his father for nearly 3 years. Dad says the relationship has been allowed to disappear. Mum says the child simply doesn't want contact. The child says he doesn't want to see his father. There are no findings of abuse, no findings of harm. So what should the court do? Try to rebuild the relationship or accept that it's already too late? And until next time, you be the judge.